What do you do if your family members are not cooperating with you? What do you do if you are entitled to a share in the ancestral property of the family, but you are not being given a share? You are being excluded from all the discussions, and you are basically put on the side, and nobody's showing any interest in giving any property to you. What do you do in such a situation? How do you file a suit for partition in the state of Telangana? That will be the topic for today. Hi everyone, my name is Ramana Reddy and I'm a practicing lawyer in the High Court of Telangana. On this channel, I help you by simplifying complex legal concepts. For tips, tricks and general legal information, make sure you hit the subscribe button below. So let's say that you're being excluded from ancestral property and now you want to file a partition suit in Telangana. What are the different steps that you have to take in order to file a partition suit in Telangana? The first step is to identify the properties and to categorize them into two separate columns. The first column will be ancestral property. The second column will be self-acquired property. So what is ancestral property? Ancestral property is property that is passed down from one generation to the other. Strictly speaking, for something to qualify as ancestral property, it has to pass down 4 generations. So, from the father to the son to the grandson and to the son of the grandson. But practically, it's very difficult to show 4 generations because, at least in Telangana, the land records only go back to 1955 or 1956 when Khasra was done. So what do you do in that situation? If you can at least show that the property came, was in the family for so many years and came from one generation to another generation, you will be able to show that it is joint family property. Now the second column would be self-acquired property. Let's say, father, mother, son, daughter. Let's say father dies, father was a big businessman, he purchased 100 properties. In that case, the process, the father's, it's his property. You cannot go and tell the father, you give me a share of that property because the father has earned it himself. He did not importantly get it from the family. He earned it, or let's say the father has a rich friend. The rich friend gifts a piece of property to the father. Again, he did not get this through the family. So therefore, the father is free to do as he wishes with that property. You cannot go and ask a share. So basically, you can file a suit for partition only in respect of ancestral properties, in respect of properties that are within the family over a generation or 2 generations and so on. So that is the first step, to identify which properties are self-acquired properties and identify which ones are ancestral properties. The second step would be to collect documents. So you would have to collect the death certificate. Let's say in our example, the father has passed away, leaving behind the wife, son and daughter. So you would have to collect the death certificate of the father to show that he has passed away. Second, you need to collect ID proof that in fact you are the son or you are the daughter of your father. It's easier in the case of a guy because it just says, son of so-and-so. But if the woman is married, all identity proofs are changed in the name of her husband. In that case, you need to find documents before the woman got married, say a 10th class certificate, a birth certificate and so on, to establish that she is the daughter of the person who has passed away. Third, you would need to get the property documents. So you would have to get the document showing that your father or your grandfather is the owner to these ancestral properties. Now it is likely or even possible that there's a particular family member who has these documents in his possession and he's not giving them to you. What do you do in that situation? In Telangana, you can approach a Mi Seva if you know the document number, and through the document number, they will give you the, you can pull out the certified copy of the property. Or let's say that you have a Xerox copy of the document, you can also file the Xerox copy in court and say that the original is with so-and-so person and he is not coming forward to produce it. What you can also do, if you don't know the exact details, at least you can go and you can apply for something called an encumbrance certificate of all the properties that you think are ancestral properties. And that encumbrance certificate, which you obtain in any Mi Seva, that will tell you what are the details of the properties, which you may be able to identify that, this one is ancestral property. It is important to note that in Telangana, as far as the second step is concerned for collecting documents, you also have the Dharani portal and the Dharani portal for agricultural land. So if you know the details of the property, also definitely pull out the records from the Dharani portal. Now, a related point is that it may be possible that one of the family members has, behind the back of the other family members, has got the name changed in the revenue records. So let's take, for example, that in the father, mother, son, daughter, father's passed away. The mother has secretly changed the names in the revenue records in the municipality to her name and excluding the names of the sons and the daughters. That does not matter, because in law, she is still holding the property in trust as a trustee for the others as a joint family property. So if you pull up a document and you see that the name has been changed, don't worry about it. You can still proceed and file a suit for partition. The next thing to look at is in which court you will file the suit for partition. If there is only a single property, you would file the suit for partition in a court which has jurisdiction over that particular property. If there are multiple properties spread across the state, then you can pick any court that is convenient to you, and you can tag along all the other properties, and you can use that court and you can file your suit for partition there. Now moving on, when you go ahead and you file your suit for partition, you file something called a plaint, which is also called like a complaint. Now in the plaint, you will draw out the family tree. In our case, you'll say the father, mother, son, daughter, just so that you graphically represent the family tree so that the court can easily understand who are all the parties involved. The next question to consider is there a time limit? Is there a limitation as to how long after the death can you file a suit for partition? So let's take our example. Let's say that the father passed away in the year 2000, leaving behind the mother, son and daughter. Now the daughter wants to file a case in 2023, which is almost 23 years later. Can she still do that? Is there a limitation period? Is there an expiry period beyond which the daughter cannot file? Generally speaking, in partition suits, there is no time limit. There is no limitation, because even though one party, let's say the mother, is in possession of that property, that she is deemed to be in possession as a joint family member, and therefore, nobody can tell the daughter when she should get separated from the family. It is up to her. She can do it 1 year later, 2 years later, or 23 years later. So nobody can really force her that you should separate from the family on so and so date. So therefore, strictly speaking, there is no expiry period, there is no limitation period to file a suit for partition. But there is one exception. Let's say in the year 2000, the person passes away and the father passes away. Let's say in the year 2005, the daughter goes and asks for a share. He issues a notice. And the mother writes back saying, screw you, you don't have a share. This is entirely my property. And the daughter just sits on that notice for a period more than 3 years. So 2005, she issues a notice. And let's say 2008, the 3-year period finishes. In 2009, she files a case. Then in that situation, she will be barred by time, because the law provides that once a person denies your title, then you have 3 years from then to file a suit for partition. So if somebody has denied your title in the family, and it becomes important that you move immediately and not wait. What is the court fee that is payable for a partition suit in Telangana? The court fee is governed by a section 34 under the Telangana Court Fee and Valuation Act. Now section 34 is broken down into 2 subsections which contemplates 2 different situations. So let's go back to our example. I think it's just helpful that way. Let's say father, mother, son, daughter. Let's say the father passes away in the year 2000. Let's say the father owned 2 properties. One property, the mother has, let's say the mother and the son together have excluded the daughter, and they have sold that property secretly. And there's another property that is still within the possession of all of the joint family. Now, the Court Fee Act, Section 34, provides for two different mechanisms for how court fees to be calculated for both these properties. So let's take the simpler case first. The case where the property is still not sold. It is still in the joint possession, or it is deemed to be in the joint possession of all these three people. Then in such a situation, the court fee that is payable is only 200 rupees, and this court fee is payable directly to the court. So that is simple, and you don't have to shell out a lot of money for that. But where things get a little expensive is when one of the family members sells a property or to somebody else. So in our case, let's say the mother and the son together, by excluding the daughter, sell the property to somebody else. Now, you want to also seek, the daughter now wants to seek a partition of that property also, because even that property is ancestral property. So, and they didn't have the right title or interest to sell that property to a third party. So what would she do? And how much court fee would she pay? So what the daughter would do is, insofar as the property that is sold, she would first obtain a market value certificate from the sub-registrar's office for that particular piece of property. Let's take just for example, let's say, and the market value is 1 crore. Then she would calculate what would be her share. And this is again only for the property which the mother and the son have sold. So 1 crore property market value as per government rate. She would calculate that. So step 1, she would obtain the market value certificate. Step 2, she would calculate what would be her share. Now there are three people who are left behind, the mother, son, daughter. So it would be 33% is her share. So that would come to 33 lakhs. That would be her share of that particular piece of property that has been sold. Now out of that 33 lakhs, she would calculate 3/4 of that market value, which comes to 24 lakhs 75,000. So she would take 3/4 of that market value. And on that 3/4 value, she would pay 1%. So in our case, she would pay 1% of 24 lakh 75,000, which comes to 24,750 in respect of that piece of property that has been sold. So if we add the entire court fee now in respect of the property that was not sold plus the court fee for the property that is sold, so it will come to 24,750 plus 200 for what was not sold, will come to around 24,950. You can pay 25,000. Just pay as a round figure. So that would be the court fee, at least in Telangana, to file a suit for partition. Now, what would be the prayer in the suit? What would be the relief that you would ask for? So firstly, if the daughter is suing the son and the mother, she would say, grant me 1/3 share in these properties, and you would list out these properties separately and in different schedules in the plaint. And she would say, allot 1/3 share to me and pass a preliminary decree allotting 1/3 shares to me. The second prayer would be, if there are sales that are already made, she would make a prayer saying to declare those sales as null and void, to declare those sales as not binding on the daughter, because these sales were illegal sales. I have a right in the property. By excluding me, they have sold this. So, the daughter would make the purchasers also a party to the partition suit, and she would say that the property that you have purchased, that is not a correct sale. So I am asking for a declaration that the sale be nullified, that sale is void, a declaration that the sale does not bind me. So that would be the prayer. If she succeeds in the partition suit, the next step would be, after she's granted a preliminary decree where she says, okay, 1/3 share in 1, 2, 3 properties and so on, and then an advocate commissioner or somebody from the court would be appointed to go physically to the court, to these properties, and to divide the properties by metes and bounds, and then allot shares to these 3 people. Now there may be cases where the property is not capable of being divided, so just the daughter can buy the son and the mother out, or all three of them can get together, sell the property, and share the proceeds of the sale. Basically, this is the procedure to file a partition suit in Telangana. I hope this video was helpful. Thank you for watching.